We're consulting on reform to a key piece of commercial leasehold legislation, the Landlord and Tenant Act 1954. The Act is relevant to the millions of businesses in England and Wales that occupy their premises as tenants and to their landlords. It gives business tenants the right to renew their tenancies when they would otherwise come to an end, allowing businesses to remain in those premises. The right is known as security of tenure. This is our second phase of consultation. In our first phase, we asked fundamental questions about whether security of tenure should continue, and if so, what form it should take. Having considered the responses, we published our provisional conclusions in June 2025. In particular, we concluded that the current model, which gives tenants security of tenure by default unless the parties opt out, is the right model for the modern commercial leasehold market. In this second consultation paper, we build on that conclusion by looking in detail at how the regime operates in practice and how it could be improved for all those that use it. We've been told that the 1954 Act is not working smoothly for tenants or landlords. We're aware of reports that aspects of it are burdensome, unclear, and out of date. So, in the second consultation, we ask questions and make proposals across a wide range of issues with a view to modernising the 1954 Act and ensuring that it's widely used, clear, and beneficial for tenants and landlords. I'll highlight 5 of the key issues we're consulting on. First, to increase flexibility in the short-term lettings market, we ask about removing from the scope of the Act more short-term tenancies where neither party is likely to expect to have security of tenure. Second, we propose simplifying the contracting out process, which must be followed to opt out of security of tenure. Third, we consider how the 1954 Act deals with environmental matters affecting commercial buildings, including the minimum energy efficiency standards regulations. Fourth, we ask whether courts should be able to include modern rental models such as turnover rents in renewal tenancies. And fifth, we explore how disputes are resolved, including whether cases should be decided in the tribunal or High Court, and considering whether alternative dispute resolution has a greater role to play. Overall, we're carrying out a comprehensive review of how the 1954 Act operates in practice, with a view to ensuring that it supports the efficient use of commercial premises now and in the future. We're keen to receive responses to our consultation from as many people as possible. That includes landlords, tenants, representative bodies, professionals such as lawyers and surveyors, and academics with a research interest in this area. The responses we receive will provide the evidence we need to develop our final recommendations for reform. It will then be for government to decide whether to introduce legislation to Parliament. The consultation runs for 3 months and closes on the 16th of September 2026. The best way to respond is through the online form available on our website.